Right. Let's just go on with the lesson for now. I will definitely redo this front part. You can't hear anything. Rapalang, can you just sort that out for me and just see why the person can't hear anything? Yeah. All right. Oh, sorry. Let me just go on again. Right, let's just go on with this lesson from now. I will redo the first part and reload that up for the students as well who missed that part. Okay, so I've given you an example of absolute force. You will all agree with me that if that person, that tiny female who has a knife in her hand, is unable to actually resist the bigger male who takes her hand and plunges it into the knife into a third person's body, that she will not be able, there's no voluntariness on her part to actually commit this act. So that is absolute force taking over, and this person will not be guilty of this crime because of absolute force. The next one is relative force. Now, in this force, that ability to subject the person's bodily movements to his will or intellect is still intact. In other words, where the tiny, in absolute force, where the tiny female could not control her bodily movements because the bigger person was taking control of her bodily movements, here there's no control over the bodily movements. The person is basically, a person can still control his own bodily movements to do something or not to do something, that here we are doing something, but the person has a choice, as for example in the Goliath case, where this person was acting under compulsion. Now, Goliath case is discussed in your studying unit under necessity. So it is later on in a later study unit, but and it is one of your prescribed cases. So you need to know this case and the case facts of this case, as well as the legal question and what the decision of the court was. Now, in this case, as I said, for example, Goliath was ordered by another person to hold the deceased, because he was killed, tightly so that the first person could stab him. And Goliath did not want to do this, and he was threatened with his life. The person said to him, if he does not do it, he will kill him as well. So Goliath did do it. And later on, they were both charged with murder, but the first person, accused number one, was convicted of murder, while Goliath was not found guilty of murder because he acted under compulsion. There was a relative force present. So you can see the difference here. The one absolute force is the way you do not have any control over your bodily movements. The relative force is where you still have control over your bodily movements, but you have to make a choice whether you are going to be killed or whether you will do whatever this other person is asking of you. Natural forces is just like the little picture explains to you there, is basically any hurricane or any weather that damages anything like a house or a shop window. So there's obviously there's no voluntariness there. For example, now if somebody is blown through a window by a strong wind, and he damages the window, he did not have any voluntariness on that part. Oh, there we go. And then the last thing we have to look under voluntariness is automatism. Now, automatism is just like the word itself says. It's where the person behaves like a robot or automaton. So it's a mechanical behavior. And in which type of situations will we find something like that? Now, we will see that there are two types of automatism. The first type is sane automatism, and the second type is insane automatism. Now, the word insane is not a very sensitive word. These days, they prefer the word mental ill, but the term insane automatism still exists, and that is the term that we have to use in criminal law. Now, sane automatism is described where a person momentarily acted like an automaton, and that excludes your voluntary act. It's just for that one moment. The person has full control over his bodily movements, but just for one moment he acts like a robot, and that will exclude his voluntary act. Now, if you have to prove that you committed an unlawful act, but you did not act like yourself for that brief moment, the onus of the proof that the act was performed rests on the state. Okay, but X, the person who actually committed the act, must provide evidential basis for their defense. For example, he must call medical or expert evidence. The medical or expert evidence will show that, yes, this person for that brief moment was not acting like himself. Now, you can see already that this is a very dangerous defense. If the defense is successful, X leaves the court a free person. He's found not guilty and he may leave. Now, we have an old case there, the Dlamini case. In this case, a mine worker was sleeping next to another person and he had a nightmare. And in his nightmare, he dreamed that he was being attacked. So he stabbed, in his dream, he stabbed and he killed another person who was lying next to him, sleeping next to him while having this nightmare. And Dlamini was found not guilty because of sane automatism. But now again, sane automatism will not always work. Now, if here is one of your first cases for this chapter, that you have to know, and that is the S versus Henry case. Now, I give a very brief explanation there of what this case is about, and it is about about Henry, who was divorced from his wife, and he had 3 daughters, and the daughters stayed with the mother. But Henry could go and see the daughters at a certain time. But the daughters could stay with Henry on certain weekends. And one of the daughters asked whether she could stay with her father a weekend. She asked permission, and her mother refused permission. And Henry then drove to his ex-wife's house with a firearm, and he was quarreled with his wife, and he was enraged. And then, according to what he said in court, he had a sort of a zinging noise in his ears, and then there was just shouting, and the next thing he heard was banging noises, and he said that he did not intend to kill his wife, and that he just momentarily acted like an automaton. He was so enraged, by his ex-wife, that he just for that moment lost it. So he momentarily acted like an automaton. Problem is, he did not only shoot his ex-wife, but he also shot his mother-in-law. Unfortunately for him, his defense failed, and there's no reasonable possibility that the accused was in a state of automatism, according to the court. So that is a very short summary of what the Henry case is about. And you can see that the defense of sane automatism will not always work, as the Henry case illustrates. Right, so that is sane automism. Sane automism means a person who is sane, or, who's not mentally ill, and he only acted like an automaton for a brief period of time when he committed the criminal act. Insane automatism is where the defense of mental illness or insanity, like I said, the word insanity is an old word that we don't use anymore. So the defense of mental illness is insane automism. Now, mental illness is also discussed in your study unit 8 in your study guide. So I'm not going to say much more than to say that if you plead the defense of insane automatism, the onus of proof is on you to prove your mental illness. Again, if you have to prove your mental illness, you can't expect a mentally ill person to prove his mental illness standing in front of a court. You have to get use of medical, make use of medical evidence or experts to come and prove that this person is mentally ill. And normally you will also be assessed in a hospital, a psychiatric hospital before the time. Now, even if you are successful with this defense, you are still committed to a psychiatric hospital and you lose your freedom. It's not like sane automatism where you just, when you are successful, you are set free. You are a free person. The last one that we have to look at is antecedent liability. Now, in such cases, the person X knows of the risk, but he still proceeds to act. So, for example, in the case of Victor. Now, Victor is not a prescribed case. You will see that we make use of many cases in the study guide just to illustrate certain things, but it does not mean that you have to know the case name. So you can just say in a certain case, Victor, okay, just in a certain case, in a decided case. In Victor, this person knew that he had epileptic attacks. Okay, the doctor also said, you cannot drive because you have epileptic attacks, but he still drives. If you make an accident while you know that you have epileptic attacks, then you are obviously guilty. So that is antecedent liability. You know beforehand that there's a risk, but you still proceed to act. So you perform voluntary conduct even though a risk of involuntary conduct. For example, those people suffering of diabetes, epilepsy, low blood pressure, and other medical conditions. You are liable for these crimes, and the crimes require only the culpability in the form of negligence. It does not require anything else than negligence. I just want to move. There we go. Now, we've looked at acts. Now we're going to look at omissions. Now, omissions, like I said, is basically just in basic English, not doing something. So it's the opposite of act. Now, there is a legal duty to act positively in certain areas. But you must remember that an omission is only punishable if there is a legal duty upon the person or X to act positively. And remember that a moral duty is not the same as a legal one. So in other words, if a child is in a swimming pool and the child is having problems and it seems like he's drowning or she's drowning, I don't have a legal duty to act positively and go and save the child from the drowning, but I have a moral duty. And it's upon me to know, to see whether I'm going to act upon the moral duty. All right. Then the legal convictions of the community, that legal duty to act positively comes from the legal convictions of the community. And these legal convictions of the community require X to act act positively. And there is another prescribed case, Minister from Police versus Evils. Now, this case is also in your is also a prescribed case, and it is in your reader. Please remember that those old Afrikaans cases, like this one, Minister van Polisie versus Evils, these cases have been translated for you into English. So please have a look for the English translation of these cases. It is also uploaded on my UNISA for you. Now, in Minister van Evils, Minister van Polisie versus Evils, it was basically just in a police station where the plaintiff, that's not Evils, he was assaulted in a police station by a police sergeant who was not on duty. But this assault took place in the presence of other policemen who could have prevented this attack. So Evils then claimed damages for the assault from the Minister of Police, and that is what that basically, very shortly, that case is all about. Now, there's a legal duty to act positively. These legal duty, like I said before, can only be upheld in certain specific instances. Now, I've listed some instances there for you. I'm just quickly reading because the next slide will explain it better. You may be you may have to act positively in the case of a statute. For example, a statute may tell you or request you, impose on you the duty that you must act positively. For example, filing of tax forms. Every year we have to file income tax annual tax forms, returns. So that is a legal duty to act positively in terms of a statute, but also in terms of of common law. Now, for example, and I've got it in the next slide as well, something like high treason, which is a common law crime. It is required that if you know of somebody who is planning or has committed a crime of high treason against the Republic of South Africa, you have to make this known to the police as quickly as possible. Else you are guilty. So there's a legal duty to act positively on you in terms of the common law. Then agreement. There may be a certain agreement made between persons or instances. For example, and we give that case for you as well, the Pitwood case, where there was an agreement that X had to open and close a gate every time a train went over a crossing, and X did not do so on one occasion, and this caused a huge accident for which he was held liable. So there is agreement. The next one is responsibility for control over dangerous or potentially dangerous objects. Now we've got that gun shooting there. If you are the owner of a licensed gun, you have the responsibility to put the gun in a safe place where people are not, like children, will not be able to reach the gun or make use of the gun. In the study guide, we give the old case of Fernandez, where he kept a baboon in a cage, but the cage had big holes in it, and the result that the baboon escaped and he bit a child. So X had the duty to fix, that legal duty to act positively, to fix the holes in that gate so that the baboon would not have escaped. The next instance is the protective relationship. Now, every parent and every guardian has a protective relationship towards a child. Every parent and guardian must feed a child, must clothe a child. we give the example of the case of B, where a young girl was sexually assaulted by her mother's boyfriend. And of course, the mother had a protective relationship to protect a child against such assault of another person. And she did not do that. She omitted to do that, where she did have a legal duty to act positively. A previous positive act, a duty may arise from a previous positive act. Now, I'm just going to explain to you that is where you as a person do something positive, and you have to act, and a legal duty to act positive on that positive act. For example, where you are in a veld, or an area where you are having a braai, or you make a fire, you have a legal duty. Okay, your positive act is making the fire. You have a legal duty to act positively to actually extinguish that fire after you have made it. So there is another, and the last one too is office. Now, office is basically if you're an incumbent of a certain office, for example, a minister, and again, the evils case will be there. The police have a duty to protect, to come to the assistance of someone who is being assaulted, even if it is by one of their own police persons. They have to protect people. I mean, that is what they are there for. And the last one is an order of court. Your legal duty may arise by virtue of an order of court. For example, if two people divorce, there's usually, well, there's always a maintenance order, and X must pay Y maintenance every month, or that is by order of the court. So he has a legal duty to act positively, and there's those cases. Now, there we go. There we have the legal duty instances, and we have examples of that as well. So that is going to help you as well if you want to memorize those legal duty instances, and you have to give an example for that as well. Right, at the bottom, we ask you a question, and that question is also in the study guide. Does the state have a duty to protect citizens from a violent crime? In the study guide, we give you two cases. These are not prescribed cases. We give you the Carmichael case and the Van Duijvenbode case. In both cases, both these cases are civil cases. In other words, not criminal cases. Both cases were successful because, let me just quickly say, Carmichael, it's where Carmichael was assaulted for by a man who had several previous convictions for violence, and he was on bail. So while awaiting trial on charges of rape and attempted rape, he basically assaulted another victim. So Carmichael claimed damages from the state on the basis that the police was negligent in protecting her against being assaulted by a dangerous criminal. Now, like I said, this was a civil case, and she won. The same with Van Duijvenbode, where in Van Duijvenbode, it was claimed that X had threatened to kill members of his family, and the police knew that. But the police did not take the necessary steps to ensure that he does not have a firearm, a gun, or that he does not have a license to possess a firearm. So at the end of the day, X shot and injured Van Duijvenbode, who then instituted a civil claim for damages against the state on the basis of a negligent failure to act positively to protect her. Now, although these two cases are civil cases, we do argue that because Both these cases are based on criminal liability by means of an omission, that there's no reason why it should not be recognized in the future as criminal cases as well. So in other words, in the future, perhaps we can make criminal cases against the police, Minister of Safety and Security, for not protecting us from violent crime. Now, this is a discussion topic, so if you want to discuss it later, we can do so. The last thing we have to look at in this study guide is the defense of impossibility. Now, just like an act, an omission must also be voluntary. So it has to be possible to perform that positive act. But sometimes people say it was impossible for me to actually perform that positive act. And that is called the defense of impossibility. If you want to claim the defense of impossibility, there are 3 requirements that you have to adhere to. The first requirement is that the legal provision which is infringed, okay, must be place a positive duty on you. Now, I'm just going to explain that because it sounds just sounds strange. A legal provision is a statute or a municipal regulation or something like that, and it has to place a positive. In other words, where it is written down, it has to say you must or you have to do something. It must not tell you you should not do something. All right, so it must place a positive duty. So you have to attend a meeting, okay, at that time. That is a positive duty. The word not must not be there. That's a prohibition. You are not allowed to do something. That's a prohibition. Okay, so that's the first thing. The second one is that the impossibility, if you look at it, it must be objectively impossible, not subjectively impossible to comply with the legal provisions. Now, remember the difference between subjective and objective impossibility. Subjective is from the person itself. Okay, it's how that person views the situation. Objective, it is the reasonable person test. So it is that no person in that position must be able to comply, not only that person who claims the defense of possibility. And of course, inconvenience is no impossibility. And that is where, for example, in Liu's case, he drives without a license. And when he gets caught, he says it was impossible to go and renew his license because it's in a different area. And that is not, that's just an inconvenience. It is no impossibility. Right. The last one is quite self-evident. That is where X must not be responsible for creating the situation of impossibility. In other words, if you say you cannot attend a meeting because your car is broken, you must not be responsible by actually stabbing your tire, so that you've created that situation of impossibility. Guys, that is it. There we go. That's basically just a reminder again that these notes are just supplementary. And thank you so much for listening to me for this class. And we will now go over to asking questions. If you want to ask a question, please just raise your hand. And I will try and unmute you one by one. Rapelang, I would be glad if you can help me here as well. Any questions, guys? All right, there we go. Thank you so much, guys. Let me just I want to see the hands. There we go. Oh, Mrs. Zing, I'm going to unmute you first. You're right at the top. Oh, just a moment, guys, just a moment. All right, I'm back again. Let me just quickly unmute Rapalang as well. Sorry about that. And then we're going back to, to Mrs. Zing. Okay, Mrs. Zing, you've been unmuted. Please ask your question. And I hope it's not on Chinese law because I don't have my Chinese book here.
Good afternoon, Professor.
Good afternoon, Mrs. Zing.
Yes, I did ask you one question, but Mr. Robosa already replied me. It's only I have a little argument there because it's really based on a case happening in China. It's regarding a policeman. Okay, actually, I think it's two policemen. Okay, they did not, jump into the pool to save a child who is actually drowned to death. Okay. And the reason we found it out in the end, okay, is because the two policemen actually cannot, swim. So it means, okay, if they jumping in, definitely they're going to be, also there is a risk, the both of the policemen will be drowned too. I'm just using, okay, what we have learned, okay. I feel a little bit, difficult, okay, to implement, okay, the defense of impossibility, because
I mean, no, I understand what you mean. Okay, you say that two policemen did not jump in to save a child. Is that correct? But
yes.
Okay, they cannot claim. What would their reason be for impossibility? There cannot be a reason for impossibility. And I think especially that, remember that one of the legal duties is by means of office. And like I said, a policeman has a duty to help the general public. I mean, they are there to protect the general public. So yes, the normal person has a moral duty to perform a positive act. But I think a policeman, according to my view, by order of his office, the policeman will have to act positively there. Is that all right with you, Mrs. Zing? As I know already, you will write me emails as well, and we will debate and argue this afterwards. So if I have not answered you satisfactorily, we can debate this later as well.
No, Professor, I actually, understand what you mean, because in my understanding, there should be like a basic, requirement or qualification. The policemen actually should be trained, like, they are supposed, to protect the public,
yes,
interest, safety. So it should be a basic skill. They should have learned, how to swim. Yeah, because why I'm asking about the defense of impossibility, there is also another similar case. I just cannot recall, but it's talking about in a fire. They talk about the fireman. Okay, the fireman. Actually,
yes.
Suppose because their duty is okay. They are the front line to combat with the how you see the risk. Sometimes they can risk even their life, especially like the fireman. Okay.
Yes.
And I can't recall the completely story, but the thing is, okay, in the end of the day, the people died, okay, in the fire.
Yes.
And actually the argument is, okay, how to judge, okay, whether the fireman is really how can I say, perform their duty, not okay, not like okay, the visual, they're taking the excuse like okay, they possibly could die, okay, so they may not okay try like 100% duty, their possibility, I mean, to save, okay, the person. This is only the case, where I'm just finding, okay, it's difficult, okay, to use, okay, defense of impossibility, to, how can I say, to defend, for the especially professional person. I talk about that the person has a duty, to fight against, the danger.
Yes.
Yeah.
Yeah. Now remember that one of the things is that it has to be objectively viewed. In other words, it's not only for that person, who says that he cannot. It's impossible for him to go and save that person from the fire because objectively the fire is too strong. So that has to be viewed by the general person. Okay, according to the reasonable man test, will everybody agree that the fire was too strong, that the fireman could not enter the house? It was too dangerous. The same with the policeman that you said. There were two policemen, and they said they could not swim. Now, it's funny to me, like I said, that both policemen could not swim, but they still, according to their duty, they can do something to help at least, the child who's drowning. All right. Mrs. Zeng, I'm going to basically ask you to mute yourself again. I'm going to go on to the next person so that we can get more questions. Is that all right? All right. The next person. Yes.
Professor Molema,
Yes.
I just wanted to ask, if it's okay with you, I don't know if you will struggle to see the hands of people from where you are, but in case you do, I don't mind just alerting you to the next person that.
Mr. Ramosa, your assistance is always valued. I can basically just see from the top, and it basically says Nosipho Mtubu, then Funega Matapelo Letuma. So is that the same list that you have?
Yes, I do. Nosipho
right.
and Funeka, yeah. So you can proceed.
So I can see those for now. As soon as if you can just alert me to somebody that I've missed, or if people are waiting too long for their term to ask a question. But again, your assistance is always appreciated.
Okay, will do.
Okay. So the next one is Nosipho Mtubu. Nosipho, I'm muting you. Please ask your question. Nosipho, please unmute yourself. Hi, Nosipho. Can you hear me? Hello? Okay, guys, I see she is unmuted, but I cannot hear anything that she says. Nosipho? Nosipho? All right, can we come back to you, Sisi? Oh, okay. Let me just quickly, I'm just going to unmute her again. I'm going on to Matapelo. Helen?
Afternoon, Prof.
Good afternoon, Matapelo.
Can you hear me?
Yes, very clearly. Thank you.
Afternoon, colleagues as well. Ma'am, I have two questions.
Yes.
Yeah, one is pertaining relative force. The other one is pertaining protective relationship.
Yes, of course.
I'll start with the one for relative force.
Yes.
How do we then prove relative force as a defense if the accused does not recall what happened anymore?
Okay, now a relative force is not sane automatism. Okay, I think you're confusing those two. A relative force is where that is just where you still have your ability to control your bodily movements. All right. In other words, somebody is not overpowering you and making you do things that you do not want to do. Okay.
Yeah.
So
okay.
a relative force is where you still have but somebody is forcing you to do something that you don't want to do. But if you don't do it, you will die yourself.
Okay, let's say it's in automatic state, then how do we prove if like the accused does not recall anything and we are using like automatic state as a defense?
Yes. Now
So
we
how
had
do
that.
we prove it?
Can you still remember the one of the slides that it says that the onus is on the on X to prove? All right, at the state must,
Okay.
and they make use of evidence. In other words, eyewitnesses, or all the type of
Okay.
yeah. So that's the
Okay.
only way that they can prove it. Very good question.
No, I understand then. Protective relationship. I'm not sure if I'm using the correct term in this one. Ne?
Yes.
Can bodyguards be held responsible for the death of the subject they were protecting if they omit or rather run away when it's their time to perform a positive act?
Okay, now the bodyguard will have a contractual obligation. In other words, the person who has hired the bodyguard will have a contract. So that will, it's not like, I'm a parent, but I don't have a contract to look after my child. I mean, that is just our protective relationship that I have to do that. So protective relationship with a bodyguard is completely different. It is according to a contract. So it's contractual.
So where does it fall? Like if we had that instance occurring, where would it fall on?
I think it will definitely, I don't know whether it will be a protective relationship that there was an omission or there was a legal duty to act because of a protective relationship.
But doesn't signing a
It
contract
can fall under it. It can, of course, because it's a contractual duty to protect.
Mm.
All right, but it's not like a parent or a guardian.
Okay, thank you, ma'am.
Okay, Matapelo, keep well.
Thank you. Bye.
Bye. All right, the next one is Letuma Bosaletsi. I'm unmuting you. Letuma.
Yes, Prof. Good afternoon, Prof.
Good afternoon, Letuma. How are you?
I'm good. And yourself?
I'm fine, thank you.
Yes. I just want to check on the duty of morality, the one you explained in the slide. I think you said it's not punishable, isn't it?
No, it's not punishable.
Yes.
It depends if it's a moral obligation. It is you yourself and your moral beliefs that will make you act or not act. If I feel no, I'm not going to help this person, I don't want to get involved. That's a moral. For example, if I walk past a man hitting a woman, okay, in a little side street. Now it's my choice, my moral obligation, whether I want to get involved or not. All right, I can say no, I don't want to get involved. Then it's on me that that's morality. There's no legal duty for me to interfere because I'm just a normal person.
All right. So, no, the question I was going to ask, thanks for that. I think it clarified things from my side, because the question I was going to ask was that maybe you see a child drowning and the person can assist the child and the person is able to swim, is competent to swim, but is just looking at the child drowning and dying.
Yes.
So the person decided not to help the child.
Yes.
So it falls under the moral duties as well, even though the person is able to help the child.
Even though if the person doesn't have a legal duty to help the child, all right, there's no other duty, there's no moral duty for that person to there's no other duty for him unless it's his own morality telling him, I can do it, let me help this child, let him drown. But yeah, that it's terrible to say that, but there's no legal duty for that person. All right, I've answered the question there. And you've gone there. I don't know where you are, but you've gone, you've disappeared. So I'm going to ask Monwabisi Nkomentaba to ask his question, or her question, sorry. Please unmute yourself.
Good afternoon, Prof.
Hi,
I think
Monwabisi.
mine is, good afternoon, thanks a lot, Prof. I think mine pertains to the whole issue of the nightmare. How does one prove that a person was in a nightmare after they have killed somebody? I think that's the one I'm a bit unable to say. How do we? I know you said, I saw in the slide somewhere that there's a case by Dlamini.
Yes.
It would be interesting to know what happened exactly, what sort of evidence was presented so that that person was I'm not sure whether to use the right word, was vindicated or not found guilty of murder
Okay.
under those circumstances.
All right.
Yeah, thank
Now,
you.
like I said, Lamini is a very old case, and we use that as an example. But like you have your doubts, I also have serious doubts that will go through courts these days, and he will or the person will be set free. But in those days, he was a believable person. His testimony was believable. People who testified on his behalf was believable. Normally, also, they will ask, because remember, he was sleeping with a lot of other persons in the hall. From the witnesses, for example, I don't know whether there was medical evidence, but from the witnesses, they would declare that, yes, he would have frequent nightmares, violent nightmares, where he would fight with people. But yes, how this he came to murder the other person, I would not know. But this is the only case that I know of where from a nightmare you are set free. Now, I know many people think that that's perhaps a good way to get rid of a spouse, but I doubt whether it will work. All right, thank you, my dear. All right, going on to the next one. Let me just quickly. Is Amanda Hlengiwe. Amanda Hlengiwe. Please unmute yourself.
Hi, Prof.
Hi, Amanda.
I just wanted to, it's not really a question, but I wanted more clarity regarding the defense of impossibility. Yes, going on the legal provision that is infringed must place a positive duty on X.
Yes.
Just that part. Can you just go over for me a bit?
Yes, of course, because it is quite confusing. I agree with you. The legal provision is basically whether it is, like I said, a provision in a statute or whether it's a rule in a municipality regulations or something like that. But it has to state the rule has to state you must do something. All right. In other words, you have to cut your grass every week or something like that. It must not give a negative, it must not be a negative statement. In other words, you must not cut the trees or whatever from your neighbor or something like that. It has to be a positive statement. That's as easy as that.
Okay.
All right.
All right.
They have a very funny example here of a fishing one. I think it's Canestra or something like that.
Canestra.
Yeah, is that right?
Yes.
Where he was found guilty that he caught fish and the fish were too small. Okay. He said that if the net, the holes of the net was too small as well. That is why he caught the smaller fish, the undersized fish. So he should have made use of bigger a net with bigger holes so that the smaller fish would go through. So because he said it's impossible for me not to have caught I just put my net in the water and I catch the fish. All right. So it was, in this case, it was rejected, first of all, because of the explanation that they gave with the larger net, the holes in the net. And also they say that there is no positive obligation stating that you must fish for a living. All right, it's terrible but okay, that's exactly what they found in that. It's an old case. I have confused even further, Amanda.
Yeah, not really, but I think I'll also just try and find similar cases to it.
All right, my darling. Thank you so much. So you may send me the cases if you find it. All right.
Okay.
Thank you,
and there's something I wanted to add.
Yes.
There's a guy who just asked regarding the death and nightmare. I'm just asking now in the future, is it possible that also circumstantial evidence will play a role? Because now it's just a housewife and the wife and a husband in the house, and one is killed. It will be really hard, obviously, to prove.
It will be very hard to prove unless there is medical backup, for
Yeah.
example, yeah, or something like that. Very hard to prove. You're right. You're hard
Oh,
touching you.
all right.
All right,
Okay.
my dear. Have a good
Thank
evening.
you so much.
Bye.
Bye.
Prof. Molema,
Yes, sir.
can I say a few things?
Yes, you may. But you may answer a few questions for me as well.
I'm kind of doing that so far. I see a lot of questions around the legal duty question. So let me just explain it to help our students to contextualize it. There are legal systems. For example, some civil law countries, maybe France and so, whereby there is a general duty upon citizens to prevent crime or to intervene in every situation. But South Africa has adopted a different approach, which is more more common in the common law systems, and that is that there is no general duty upon anyone to prevent crime or to assist in any situation. The only scenario is if there is a legal duty upon you to act positively. So over the years, certain instances have crystallized in our law, as Professor Molema has explained. Those specific instances are crystallized instances that over time have become instances recognized in our law as imposing a legal duty. But in the absence of any of those instances being applicable, then we move to the general principle, which is, do the legal convictions of society demand or impose in this situation that there should be a legal duty to act positively? So, for example, in that scenario where you see the picture of a man in the study guide and a child swimming there is no exact case law that regulates that situation. So you would move to there's no specific instance that regulates the situation. So you'd move to the general principle and ask yourself, given the facts that you know of, would the legal convictions of society demand or impose that there should be a legal duty to act positively? So that will help you to understand where that principle comes in. That I hope that clarifies that issue. When it comes to the aspect of voluntariness, as Professor Molema has explained quite well and succinctly, the important thing is to know the definition of voluntary conduct. So in the case of the nightmare, where it happened, obviously the evidence of the accused would be presented, and then the court will have to assess the evidence and assess which element of liability is doubted or called into question. And naturally, in such a situation, if the evidence demonstrates that the accused was unable to subject his bodily movements to his will or intellect, that would mean that he did not act voluntarily, and therefore the conduct element would be missing. And if conduct is lacking, there is no point continuing to investigate the other elements of liability. Remember the step-by-step approach. Conduct is the first one that you check, and then if conduct is present, you move on to check whether it complies with the specific deficient elements contained for the crime to be committed, and so forth. So in this instance, because there was no conduct, the accused was found not guilty because of lacking the conduct element. That was the situation with the nightmare case, the case of Dlamini.
Thank you, Mr. Ramosa. Mr. Ramosa, can you hear me?
Yes, I can hear you.
Okay. I think let's move on because there are quite a few hands. I'm just quickly going to ask Monwa BC Unwabisi, did you have another question, or can you please lower your hand?
Apologies.
No, no problem. All right, then the next person wants to stay anonymous. It is oh, sorry. It's backslash. I'm going to unmute you now. Hello? Can you ask your question? Ah, there we go. No name for you.
I'm sorry, I was hard to get into this. My name is April. I just want to, you mentioned earlier that there are people who got in late, so you are going to put the first and the second slides in at the end of the class. So I'm just reminding you not to put it.
Can I just quickly ask you, maybe if you could write your question, because you are breaking up so badly that we cannot hear you at all.
All right.
Oh, thank you. Sorry about that. All right. The next question is there we go. I'm muting you, Professor Beatrix Creer. Prof. Creer, can you just unmute yourself? Okay, it seems that something happened there. I think Prof. Clear can just come back if she wants to ask a question. So I'm moving on. Sorry, I'm moving on to Christian Zungu. Christian, I am unmuting you. Christian, can you hear me?
Yes, I can hear you.
Yes,
your side?
Yeah, I'm fine. Please ask your question.
Oh, thank you, Professor, for this opportunity and our colleagues. My question is that there was a scenario where, or there was an incident where a father took his son to school, a night school. So he decided to wait for him in the car. I think the son took about 2 hours inside the class. The father was tired. Then he waited in the car. He fell asleep. When his son came back, he knocked into the window to wake up his father. His father, he then took the firearm and shoot to his son by mistake. So what I want to find out is that, can he rely on the defense of saying automatism, or he can rely on the defense of mistake, the father?
Yes, I think there was a conduct. So remember that we are still busy, Christian, with the first element, which is act. Remember, as Mr. Ramosa again explained, that's the first element that you have to do. And as you said, there was a positive act. The father did act by waking up. He did not sleep the child, shoot the child in his sleep. So he woke up and he shot at the child. So there was already a positive act. So now you have to go on to the next question, which is, does the act comply with the definitional elements? The child was killed. I think so it's murder. So yes, it does apply to the definitional elements. Then we go to unlawfulness. Is there any ground of justification that will assist this father in escaping liability?
Yes.
So that is what you have to ask. And I think this father, it was found not guilty. Is it true?
Yes, he was not guilty.
Okay, because he did not have intent.
Yes, yes.
Okay, so that is the whole last one that we have to go to culpability. Then we say, does he have criminal capacity? Yes, the father does have criminal capacity. And then we have to ask, did he have intent to actually shoot his child? And we say, no, he did not have intent. It was negligent. His act was negligent. All right, so it's definitely not to do with the first element. It's right at the end.
All right, not a
All right,
problem.
Christian,
Thank you.
but good question.
you.
Prof. Molima, can I also add to what you're saying?
Yes, Mr. Ramosa, but please, we have still many to do, and I'm sure the others also want to ask their questions.
All right, I think I want to just re-emphasize what you said about following the sequence of investigation that is presented in Study Guide 1.5.3, that you have to start first with the conduct question. Was there voluntary conduct? If there was conduct, or let's say if you have a situation whereby an omission was done in circumstances where a legal duty to act positively was imposed on someone and it was not complied with, then you ask that question, is there conduct? If conduct is present, you move forward. If it's not there, you stop there. So you can't go to intention or criminal capacity, without solving the others. That's my contribution. Yeah.
Absolutely correct. And thank you for emphasizing that, Mr. Ramosa. Let's go on to the next person. I will go back to the persons at the top who we didn't hear well. The next person is Mr. or Mrs. or Ms. Ladwaba. Can you please unmute yourself?
Hi, Prof. How are you?
Hi.
Hi. I wanted to understand in terms of insane. I wanted to understand in terms of insane optimism and sane optimism, like almost the same questions that everybody else asked.
Okay.
Like in this case, if what sort of experts would be called in the courtroom to come and prove that this person is indeed insane? Because, for instance, I could be in the house and I could be insane for a moment and I could harm a child or whoever that's in the house with me, and there would be no evidence that I was in that particular moment automated. So that's a little bit confusing for me.
Okay, now remember, you're absolutely right. And that's why sane automatism is very difficult to prove, and very few cases actually succeed with the defense of sane automatism. Because if you do not have, say, for example, medical evidence, in other words, you have a doctor who will say that you've been on this medication for this illness for so long, and these are your symptoms, and your symptoms are in line with what you did. Okay, you will not succeed with that if there's no previous evidence of you. It's not supported, especially, like I said, medical evidence. You will not succeed with sane automatism. All right. Okay. Now, insane automatism is where you have a mental illness already. All right.
And you would have to be obviously subjected to a psychiatric hospital.
Absolutely.
It's not like you're going to walk out free.
Not
Lamini.
Absolutely. You are so right there. Okay. No, absolutely. You understand that. I can see that. All right.
All right. Thanks,
okay.
Prof. Thank you.
Thank you, Mrs. Ladwaba. Bye. Okay. The next person is Kagiso Afane. Kagiso, you can unmute yourself.
Good day, ma'am. How are you?
I'm fine, and you, Kagiso?
I am well. The question that I wanted to ask is similar to the one that was asked by Ms. Ladwaba. But also what I wanted to find out, I heard that you said there has to be medical records that prove that a person is mentally unstable. Am I right?
Okay, is that now for the defense of sane automatism?
Insane automatism, yes.
Okay, no. Insane automatism, you are certified mentally ill. So in other words, you do not have criminal capacity. Remember, okay, so you are mentally ill. If they, it's not that you just lost the plot, like, for sane automatism for a period of time, okay, like having a nightmare. That's you're fine after before you went to bed, and you're fine when you woke up or whatever. But just for that period, you were not fine. You did not have a control over your bodily movements. Okay, so you cannot be held responsible because your acts weren't voluntary. Okay. Now,
Okay, so which brings me to this question, because in most instances we find that a person commits, for example, a murder, and then instead of them being convicted, they say that they're not mentally stable, so they have to go through a mental evaluation. So why is it that this happens after a person has committed the crime? Why is insane automatism applied after the person says, no, I have a mental condition and I think I need to go through a psychiatric evaluation? And why aren't they convicted like a person that is actually sane?
Okay, you mean why aren't they convicted like a person who is sane? Okay, because they are not sane. Okay, remember that if you are mentally ill, you do not have the ability, certain abilities. Okay, that's and that is in your. Let me just quickly look at your chapter, study unit 8. I'm just going to read for that. That is where, as in section 78(1) of the Criminal Procedure Act, where, and I'm just going to read it because it's something that you're going to do later on. Like I said, this is basically just a short description of those two automatisms. A person who commits an act or makes an omission which constitutes an offense, and who at the time of such commission or omission suffers from a mental illness or a mental defect, which makes him or her incapable, and this is basically your criminal capacity test, of appreciating the wrongfulness of his or her act or omission. In other words, they can't appreciate that wrongfulness, and that is a mentally ill person. They can't appreciate, first of all, or acting in accordance with appreciation of his wrongfulness of his or her act or omission shall not be held criminally responsible for their act or omission. So that's basically in section 78(1). So any mentally ill person who commits a crime will not, and it's shown through medical evidence that this person is not well, mentally well. They will not be held responsible for that crime that they committed. But then again, they will not be set free. They will be held in a psychiatric hospital.
All right, I completely understand. Thank you.
Okay, Kagiso, just remember that if you have further questions, please feel free to write us an email and we will help you further, all right?
All right.
Thanks, Kagiso. Octavius, you are next. Octavius?
Good evening, Prof, and to colleagues.
Good evening,
The question I have is with regards to legal duty to act positively and using the example of the officer. What I wanted to find out, to clarify, so an officer is an officer, of course, by that he is under the employ of, let's say in our example in South Africa, the SAPS. Now, as being an officer, there are certain duties that he has to comply with, and there is training provided at all these things. So let's say in a situation where an officer is, let's say, for example, unable to shoot a firearm, so he never received the correct training or he never completed the training, and he was in a situation where he had to use his firearm and was unable, and let's say a bystander got affected because he was not able to act. Would the police themselves, because he didn't get the training, would there be any liability on them as well with regards to this?
Now, as you described that, Octavius, according to my knowledge, yes, they will be held liable, the police or the Minister of Safety and Security, for a situation like that. But then again, the whole case, the context of the whole case have to be taken into consideration as well. If it's purely just the police's error that they did not give him proper training, it could be from the officer himself that he did not attend training, or he did not give it enough attention, or whatever, or he's frightened of handling guns, or everything. Every little point has to be investigated. But just on the basic facts that you've given, it seems to me that yes, the police will be held liable.
Thank you very much.
Thank you, Octavius. Petile?
Hello.
Hi, Petile.
Hi, good afternoon, everyone.
Hello.
Thank you for the opportunity. Okay, it's not a question as such, but I want to take it back to the defense of impossibility. You briefly explained the subjective and the objective differences, So if
yes.
I didn't catch something there, if you don't mind, can you just repeat that a bit?
All right. And remember that when we go further in the book as well, in the study guide, you will hear words subjective and objective a lot.
Yeah.
Because this is, for example, if you look at certain tests that we do, you will see that we have certain tests for intention, we have certain tests for negligence, and that is where you have to make use of these terms. Now, for example, objective is for use for negligence. All right. Now, if you objective means the whole scenario is seen from the viewpoint of all persons or the average man, not from that person who actually committed the crime. He's what he felt. All right. So that's why we said we call that like a reasonable person. Okay. That the ordinary person, the everyday person that we get. So that is the objective. That is being objective, and then subjective is just the other side.
The other way around.
The antonym. It's basically where that person himself, not from the view of everybody else, but from what that person himself believed that he was, in danger, or what he experienced. All right, that's a difference between those 2 points.
All right. Thank you.
Thanks,
because
Betty.
in my head, I was playing around with like saying being biased and being unbiased, something like that. But when you started to say it's on the person and it's not on the person, I was a bit confused. But thank you so much for the clarification.
Yeah, but Tila, you're right there, because you're biased if you think of yourself, isn't it? I'm thinking that.
Yeah.
You're right
thank
there.
you.
All right, my
All
dear.
right.
Bye.
Yes, bye.
All right, NQ. I don't know whether it's. Hello? Can you unmute yourself?
Afternoon, Prof. and your colleagues.
Afternoon.
Prof, one quick one from my side. I think it's in legal duty under antecedent liability.
Yes.
I just want to follow up with. I want to make a follow up on the example that you made that that duty, it doesn't apply to people who have a condition. Let us say is having the epilepsy. So I just want to check.
No, it does. It says that you are liable. Antecedent just means knowing beforehand. All right. So you are liable if you know. You can't plead that you don't have you do not have control over your bodily movements. All right. You cannot plead that. If you knew that the doctor told you that this medication that he's prescribing for you, you must not drive while taking this medication. You may have an accident. If you take your medication knowing that the doctor told you that, and you still drive and you make an accident, then you have no excuse. You can't say involuntary act here. All right. Do you understand that better now?
Very clear now.
Oh, thank you so much. Is it NMO or what? Okay, NQ. Thank you so much, NQ. Comfort.
Good evening, ma'am.
Hello, Comfort.
How are you, ma'am?
I'm fine, and you?
I'm good. My question has to do with automatism, insane automatism, ma'am.
Yes.
You said that a person who suffers from mental illness has to prove that they're mentally ill.
Yes, I did say that because the guide says that, and the study guides and the textbook says that.
Oh, so my question was, if like the state argues that the person does not suffer from mental illness, is it like the burden of proof has to lie on the state to prove that the person does not suffer from mental illness, or what?
No, as I said there in the study and that slide as well, and it's also in your study guide, that if the person himself, and it sounds a little bit strange, because how can a mentally ill person now have to prove that he's mentally ill? But of course, it's not the mentally ill person who has to prove. That person makes use of medical experts. Okay, medical evidence to prove. In other words, doctors will come and psychiatrists will come and prove that this person is indeed medically ill. So the onus is on that person pleading insane automatism to prove that he is mentally ill.
Oh, thank you, ma'am.
Okay, thank you so much, Comfort. Tandega Bushle Betu. Dear Tandega, just unmute yourself. Right at the top. There we go.
Hello, Prof. Can you hear me?
Hi, Tandega.
Hi, how are you?
I'm fine, and you?
I'm fine, thanks. Just a quick one. Saying automatism.
Yes.
Is it the same thing as pleading temporarily insane?
Temporary insanity, yes, it's almost the same thing. But yeah, for example, you just say, because it's right at the beginning, and remember, mentally illness is later on under intention. So we're still busy with, remember the first element, which is conduct, and we're just saying that this person's saying that for the brief period, that's not for saying automatic, for a brief period of time, he lost control over his bodily movements, and that's why he's pleading.
Okay, that's clear then.
All right, Tangi.
Okay.
Bye.
Thank you so much.
Bye.
Bye.
All right, I'm just going to because it's just coming the hands. The next one is Dinkwanyane. Just unmute yourself. Hello, you're very faint there. Can you just put up your volume?
Yes, can you hear me?
There, now we can hear you. Yes.
Yeah, I just want to draw you back from, to the earlier example of somebody dreaming while sleeping to someone else, and then all of a sudden, he kills the person with a knife or something. Mm-hmm. Now, I'm just thinking here that would the same thing, or maybe the same defense of automatism, apply to someone who perhaps, sleeps to, say, sleeps next to a woman, and now out of whatever, a claim of a dream, and then apparently, have sex with that woman. Obviously, that will be rape. Would that person, use automatism as a defense?
Oh, Dinkwanyane, you are fading away. I didn't even hear half of your question. I'm so sorry. Mr. Ramosa, could you hear him?
Unfortunately, I couldn't either.
Oh, I'm so sorry.
I'm just closer to the speaker here. Can you hear me now?
Yes, you're back again.
Yeah. No. I was saying with the earlier example of somebody who happens to sleep next to someone, and then now he was dreaming, and out of that dream, he kills a person, obviously unintentionally, but then would the same, defense in terms of automatism apply to someone who sleeps with someone, while dreaming, so to say?
It should apply. The same defense could apply to somebody if somebody's just sleeping next to somebody else and all of a sudden they dream and they stab that person with a knife.
No. This time I'm using an example of having sex with someone. Well, that person will be dreaming having sex, and then
having sex.
Yes.
Oh, you want a defense for having sex with somebody?
Why in the dream?
Okay, now we can discuss. Okay, let me give this one because I'm going to ask Mr. Ramosa to do the last two now. Let me give this one over to Mr. Ramosa. Mr. Ramosa, can you answer this one?
I laughed so much I couldn't help myself. All right, so technically speaking, assuming that somebody is able still consciously to hit the mark, whilst dreaming, yeah, I guess it could happen like that, although yeah, it will be a very difficult scenario to plead that you didn't have conduct per se. It will be very interesting. Perhaps you could argue that you didn't. You thought that there was consent, or you at the moment you just lacked capacity. But I really doubt you can say that you didn't have conduct.
Dikwanyani, I think that the person that you are forcing your advances on will wake you up very quickly to tell you no. This is unwanted.
Exactly. No, it's fine. Because I was just thinking, in line with the killing, example. To say, sometimes, for instance, somebody who may claim that I was drunk and so on, but we know with all the cases of using drunkenness as a defense, did not necessarily succeed. But then this person will say, no, hey, I don't know what happened. I was dreaming and all those things. Thank you. But thanks for the explanation. Thanks.
It's very interesting. I think we must have a discussion about that one later. Thank you so much, Dikwanyan. Let's quickly finish up because I think the time's finished. All right, let's quickly go on to Mileka Inderlal. Mileka?
Hi, ma'am. How are you?
Fine, and you, and thank you for waiting so long.
It's okay. Thank you. Okay, so I have a question. So when a person is like, they're found to be like mentally unfit or insane, what happens to their capacity to act? Is it fully taken away? Like if they have a child, is their child taken away?
Yes, you know what? That is obviously not substantive criminal law. It's more private law. But I would definitely indeed think that if somebody is certified as mentally ill, that they cannot act, yes, I think the child will be taken away. Sorry.
Okay. Is it proven? Will that happen when the medical? I know you need to get medical evidence, or when the court decides that you
It is definitely. And remember now, as you will see in private law as well, it's always in the best interest of the child. The child's best interest is always of the utmost importance. So they will have to look what is the best for the child. And if the person is certified mentally ill and they cannot take care of the child, the court will have to decide that and appoint somebody to take care of the child.
Okay, all right, perfect. Thank you, ma'am.
Thank you, Malika. Bye.
Bye.
All right, and listen, this is our last one. Mr. Ramosa, luckily my throat is better, but it's so dry now. I'm aware that it's a student number 593400517. I'm unmuting you, and you are the last person to ask a question online. But you remember, you can always post your questions or paste your questions on the chat site, or you can just email as well, and we can discuss further your questions. So Kumbo, can I please ask you to write your question down, so that, because we have to end. So we're way over our time. So unless who is the student 593400517?
I'm here, Professor.
Oh, there we go. You unmuted yourself. Good for you. What is your question?
My name is Tavi.
Yes,
Afternoon,
Tavi.
everyone. My question is, so in case of a person actually who's mentally incapable to perform, or who, and then let's say that person is an offender and keeps on repeating the same crime, but you can actually tell due to the evidence, or actually the past of the person, that they are aware of what they are doing. So then what happens, how can the state prove that actually the person is aware of what they are doing, or the person will always have to plead that they are incapable to commit such? I don't know if you get me.
Yes, I do get you. So, for example, you're just saying that somebody is mentally ill, and they use their mental illness to commit crimes. Is that what you mean?
Yes, it is.
Okay. Now, if the first time the person who committed a crime, an illegal or unlawful act, that person should have been assessed and basically be placed in a psychiatric hospital under care. But as we know, this does not always happen. Persons are released, or, especially as the hospitals are full. If this happens again, remember now this person already has a record that he was declared mentally ill. So this will make the case against him stronger already, that he is mentally, he probably will have to be put back, in a mental hospital. Remember that we cannot convict somebody, find somebody criminally liable who has a mental illness.
Okay, thank you, Professor.
All right, thank you. Okay, okay, let me just do Kumbu. I hope this, Kumbu, unmute yourself, and this must be a short question.
Thank you, Prof. Can you hear me?
Yes, I can hear you.
I just wanted to ask, in terms of the Duplessis case, where the man had an accident and he injured a pedestrian. I wanted to find out if it's not possible for the traffic department to list all the possibilities of all the possible illnesses or involuntary conducts that they can list, and say, if you are taking a driver's license, you cannot take it if you have this once in a while, if you have this epilepsy, if you cannot have this, so that it avoids that ad hoc, that once in a while disturbance like that. I don't know if you understand what I'm trying to ask.
I understand you completely. The problem, and I agree with you, it would help a lot, but unfortunately you cannot cover everything, because remember there are quite a few situations or instances where medical instances, and it comes up, syndromes and this and that, and so if that thing is not, or that illness is not listed, then that person goes off scot-free. So at this stage, they leave it up to the court, to see, it's just under a general thing that that you don't have any voluntariness or whatever, and the court will decide whether it is applicable or not.
Oh, okay.
Thanks,
okay. Thanks so much for taking me, Prof.
It's a big pleasure, my darling. All right, guys, Mr. Ramosa, will be the end of our class. Please remember that you can still ask questions online. You can still ask questions via email. We will answer them. If we can't do it immediately, we will get back to you tomorrow. Mr. Ramosa, is there anything still that you want to say? Before Mr. Ramosa says anything, I just want to say that next week for study unit 4, Mr. Ramosa will take over from me and teach the class as well as study unit 5. And I'm looking very forward to those classes. Mr. Ramosa?
Thank you, Professor Molama. Thank you very much for a very, very informative and engaging lecture. I also want to thank all the students that participated in asking questions and engaging on the chat. This is what we really crave for. So we really look forward to you engaging us. Please continue to do so in the chats even after the lecture. You may continue to post because some issues may arise out of reflection. We also would like to encourage you to pose your questions on the MyUNISA discussion forum, and be on the lookout for comments and contributions. Thank you.
Thank you, students, and goodbye.